Inside Texas Politics, 3rd edition by Brandon Rottinghause, Texas Government 2306. Chapter 10, Part 1. In December 1992, Pamela Jean Johnson collapsed in tears as a Texas jury awarded her $26 million, or $25 million, after her breast implant burst and forced her to endure a partial mastectomy. The vast sum of the largest award against a producer of silicone implants to date, and it served as a sign of things to come over the next decade. Texas courts granted blockbuster damage awards, including the first multi-billion-dollar settlement in Texas history. Some Texans cried out for tort reform, that is, laws that would limit damages granted for negligence. This battle pitted the powerful Trial Lawyers Association against Texas business interests and their Republican supporters. Republicans claimed that outrageously large awards led to skyrocketing Texas medical malpractice insurance rates, and that this was the reason Texas suffered from a shortage of physicians and medical specialists. Opponents of tort reform argued that victims harmed by negligence are entitled to fair compensation. The U.S. Chamber of Commerce had ranked Texas among the 5 worst litigation states. However, and stated that several counties were judicial hellholes, where normal rules of balance and fair play under the law don't exist. Houston-based mega lawyer Joe Jamil, who made so many millions defending clients that he was dubbed the King of Torts, objected and deemed reform initiatives as tort deform, not tort reform. Jamil and others argued that individuals who are harmed by companies or poor medical practices must be compensated properly. Coming off major electoral victories in 2002, Republicans secured passage of the 2003 tort reform law with bipartisan support. The legislator's tort reform package profoundly impacted the legal process in state courts. It reduced the number of cases the courts had to handle and helped unclog the system. In the decade after Texas implemented the tort reform, medical malpractices lawsuits plummeted 64%, and civil lawsuits overall dropped by 17%. As these events make clear, the judicial system crowns winners and losers in theory. All Texans are equal before the law and judiciary. In practice, many fear that the system is strongly influenced by the power because they have greater resources. The most obvious culprit is the fact that judges are elected in Texas. Does this allow the people the ability to hold judges accountable? Or does it give wealthy contributors to judicial campaigns an edge over others? The power struggle between political business and public interest all collide in the elections of the judges and rulings in the Texas courts. In this chapter, we explore the functions, development, and impact of judiciary in Texas. We examine how the power of the judiciary is constrained by the legislator, higher courts, and voters. Finally, we assess reform efforts that have followed political scandals and dysfunction within the courts. 10.1, the role of the courts. The judicial system's role is to interpret Texas laws in matters ranging from minor criminal offenses to those involving the Texas Constitution. Texans expect to have equal access to an efficient system that applies the law fairly and objectively, and that protects their interest. Yet is this task even possible? Interests often conflict and can be weighted in favor of one group or over another. And while Texans might expect impartiality from judges, political struggles make their way into the courtroom in many ways. In this section, we begin to evaluate the Texas judiciary by exploring its basic structure and functions. Dispensing justice. Texans did not always have ready access to the courts. Before the Texas Revolution, justice was a scarce commodity. The Mexican constitutions of 1824 and 1827 established state and local courts. In practice, however, ordinary Texans could not appeal local decisions because higher courts were located several hundred miles away in the state capital. After Reconstruction, resentment of central government swelled, and Texans reacted against the interest corporations and demanded accountability to the people. The current Texas Constitution, Article 5, divides the judiciary in Texas into many types of courts, allowing both local access and appeal to higher courts. The legislator has subsequently established additional courts to allow the state to handle a rising caseload as the economy and the population have boomed. As a result, the Texas judicial system has the greatest number of courts in the nation. See Figure 10.1. More courts mean, in principle, more access to justice for Texans. However, in practice, multiple layers of courts may increase the cost of legal verdict for many Texans. Judicial hierarchy. The structure of this court system is hierarchical, meaning that cases start at the lowest level and funnel to the courts above as appropriate. The hierarchical nature of the court system also allows higher courts to check bad decisions or incorrect rulings by lower levels. This is one way in which the court system balances competing interests and provides access to all groups. Legal jurisdiction. The legislator helps the courts set jurisdiction, the official territory and types of cases over which a court exercises authority. Trial courts often have original jurisdiction. They are the court in which the case is first heard. If one is not satisfied with the outcome and the case meets the criteria for an appeal, it may advance to an appellate court. Higher courts can generally choose which cases to take from lower courts, making the appeals process something of a gamble. Higher courts with the appellate jurisdiction review the decisions of lower courts. The appeals process can be lengthy, depending on the nature of the case and the efficiency of the court system. Cases can either be criminal or civil in nature. In criminal cases, the government brings charges against a person, the defendant, who is accused of breaking a law, such as in cases of murder, robbery, larceny, or bribery. The government must prove the defendant is guilty beyond a reasonable doubt. Civil cases involve conflict between two parties, litigants, whether individuals, corporations, or the government. The standard of proof is lower in civil cases. The plaintiff, who is the party bringing suit against a defendant who is the party being sued, must prove that the harm was done to them by a preponderance of evidence. This standard emphasizes the convincing quality of the evidence rather than the amount. For instance, a witness with clear details about an even greater weight than several witnesses with hazier recollections. Texas has many types of trial courts. So how do you figure out which court hears a case? In civil cases, the amount of monetary damages helps determine which court will hear a case. The major factor that determines which court will hear a criminal case is the severity of the transgression. A felony is the highest stage of crime under state or federal law. These offenses are more severe in character than misdemeanors, which are minor wrongdoings. The judiciary classifies the severity of a crime based on factors such as the use of a weapon and whether the crime involved violence. Interpreting the law. Texas courts interpret law by relying on legal traditions. The Texas Constitution, legislation, and common law, or judge-made law. These decisions then become binding as future courts consider similar cases. In making these decisions, the judicial branch not only delivers justice, but also acts as a check on the legislative and executive branches. Let's take a closer look at how this occurs. Clarifying laws. In their haste to make new laws and revise old ones, in 140 days, the legislator often writes laws that are unclear, vague, misleading, or on occasion unconstitutional. The Texas Supreme Court sorts out contradictions or clarifies legislative meaning. In his 2015 State of Judiciary address, Chief Justice Nathan Hecht remarked, asserting what is meant by what is said can be difficult. Try it with your spouse. Even when a statement is in writing and has been carefully considered, its application in an unforeseen situation can be unclear. These clarifications are often minor but meaningful. For example, the court clarified the term impounded in 2016 when it ruled that the owner of a missing dog picked up by a private animal control shelter does not give up ownership rights to the shelter or foster family. Checking the legislator. The courts often take on political roles, acting to check or maintain legislative decisions by determining whether legislation is constitutional. For example, in 2015, a bipartisan effort in the Texas legislature passed a statute criminalizing revenge porn, sharing intimate images without the consent of parties involved, and won a swift signature from the governor. In 2018, a legal challenge from the conviction of a Tyler man who was charged under the statute alleged that it violated free speech rights. A state appeals court struck down the law as unconstitutionally broad, prompting the legislator to tweak the law to add language that to the explicit images be posted with the intent to harm the person in the images. Defining state interests. When state interests clash with business or citizens, the court's job is often to sort out competition claims. For example, in the late 19th century, Texas transitioned from an open frontier to land ownership. In 1888, famed cattle rancher Charles Goodnight fenced in large tracts of state land, much of which he did not actually own. The state had set aside the land to generate revenue for the public school system and sued Goodnight to remove the fences. When the grass lease fight reached the high court, it ruled that the fences had to come down. Advancing the rule of the people. The courts in Texas are not expressly designed to promote popular sovereignty. However, Texans have chucked out justices whom they feel don't represent their values. In a classic example, in 1874, Texans who hoped to restore antebellum practices after the Civil War, elected Governor Richard Koch, who obliged with his supporters by appointing Confederate sympathizers to the Texas Supreme Court in what came to be called the Redeemer Court. Although the issues in cases were different over a century later, when conservatives abandoned the Democratic Party and the Democrats ran more liberal judges, Texans swept in a new cast of conservative Republican judges to mirror the ideology of the voters. 10.2 Trial Courts. Trial courts hear both criminal and civil cases. In these lowest level courts, witnesses are heard, evidence is presented in the form of exhibits, testimonies is taken, and ultimately a verdict is reached. Texas has several levels of trial courts: local, county, and state. Each type of trial and appellate court hears different types of cases. See Figure 10.2. Legal courts. Municipal courts. If you dump something in violation of city ordinances or are caught with alcohol as a minor, you'll end up in this court. Municipal courts in Texas have original and exclusive jurisdiction over violations of the city. See Figure 10.2. Ordinances over Class C misdemeanors, which carry the lowest severity of punishment of all misdemeanors. The punishment upon conviction in a municipal court is generally small. For example, if you steal property worth less than $50, speed, run a red light, engage in disorderly conduct, or are found in possession of alcohol when you are underage, you'll receive a fine of $500 or less. The Texas Legislator has the power to create municipal courts to provide Texans with a better access to justice. Larger cities generally have more municipal courts than small cities. For instance, in Houston, Harris County, population of 4.5 million, there are 28 courts. In Hill County, population 34,855, there are 6. Municipal courts handle the largest volume of cases of all the courts. This makes sense given the nature of the cases these courts deal with: parking tickets, abandoned motor vehicles, city code violations, possessions of drug paraphernalia like a bong with no drug, or a minor in possession of tobacco products. Most of the non-traffic cases, 64%, and traffic cases, 71%, end up uncontested with the defendant paying a fine or submitting a guilty plea without a court appearance. Justice courts. Justice courts are a specific type of local trial court. Contrary to popular belief, justices of the peace who administer these courts do not just issue marriage license. In reality, they hear cases that involve small claims, civil actions of $10,000 or less, and criminal offenses punishable by fine but not prison sentences. If your landlord refused to return your security deposit, you might appear before a justice of the peace to try to get your deposit back. Justices of the peace also serve as coroners in many small counties and as magistrate judges with authority to hold hearings to determine if probable cause exists to hold a criminal defendant in jail. Like municipal courts, justice of the peace courts also handle a significant number of cases. In 2019, for example, these courts handled 2.7 million new cases, in which were uncontested 87% of traffic cases and 88% of non-traffic cases, or dismissed more than 43% of traffic cases and 41% of non-traffic cases. We think of the courts as arbitrators of justice, but they are also revenue-generating agencies, putting funds back into the budget. Increasing certain fines or imposing new criminal violations has an impact on state revenue. The Justice of the Peace Courts collected more than $324 million $24 million in fees and fines in 2018. County trial courts. Constitutional county courts. Although constitutional county courts do not always deal with legal matters, they are part of the judicial structure. The Texas Constitution vests broad judicial and administrative powers in county judges who also oversee a 5-member commissioner's court. This court has a budgetary authority over county government operations. County judges also have a wide authority over several administrative matters, including hearings for beer and wine license application, admittance to state hospitals for the mentally ill, juvenile work permits, and temporary guardianship. County courts at law. Statutory. If you sue your roommate in justice court for ruining your laptop and she appeals the case will end up in county court at law. These courts have original jurisdiction on civil matters between $200,000 and $200,000. County courts at law also have appellate jurisdiction in cases appealed from other local trial courts. In criminal appeals involving fines of $100 or less, the decision of the county courts at law is final. The Texas Constitution limits each county to a single constitutional county court. So the legislator established the first county court at law in 1907 to relieve the county judge of some or all of the judicial duties of the office. Today, there are more than 240 of these courts. Probate courts. Probate courts, where they are created, hear primarily matters of probate. That is, the official recognition and registration of the validity of a person's last will and testament. These courts will only exist in the state's largest counties, a total of 18 courts in 10 counties. If you don't live in these areas, you will need to settle these estates at a county court or a district court. State district courts. District courts are trial courts that handle most major criminal and civil cases, including murder, drug trafficking, contested elections, and civil cases involving high amounts of monetary damages, any amount over $200. The district courts are often the first rung on the ladder of the criminal justice system. So many criminal cases begin here. In 2018, most criminal cases were drug offenses. The district courts have also have original jurisdiction in all divorce cases, land title cases, and any cases that do not fall under the jurisdiction of other courts. Most cases of the courts deal with are family related, 38%, followed by criminal cases, 31%, civil cases, 21%, and juvenile and other cases, 2%. A growing population leads to more family cases, more divorces, more child custody issues, paternity issues, child support orders, and adoptions. Texans charged with crimes heard by district courts can choose between a bench trial in which a single judge presides and decides guilt or innocent and punishment, and a jury trial in which a group of individuals picked at random decides on guilt or innocence. The advantages of one versus the other depend on the details of the case. See Figure 10.3. In general, a defendant in Texas is convicted in more than half the cases, especially for felonies such as driving while intoxicated, 95%, sexual assault, 74%, and murder, 85%. Prosecutors, however, dismiss many cases, 22%, for lack of evidence or other reasons. In civil cases, more than a third of plaintiffs agree to dismiss their cases, while a little over 13% end in a mutually agreeable settlement. So only about half of all cases filed actually go to trial. 10.3 Appellate Courts. What do appeals courts do differently from lower level courts? Appellate courts do not hold trials, but only review legal issues of cases decided by lower courts. An appellant or petitioner first files the notice of an appeal and then submits a written set of arguments containing the appellant's view of the facts and the law, called a brief. The justice in an appellate court may decide the lower case based on the brief alone, or they may hear oral arguments during which attorneys for both sides present their cases in person to the justices. Amicus curiae briefs, literally friend of the court in Latin, can be filed by interested parties that are not directly involved in the case, providing an avenue for outside groups to have a say in the judicial process. Interestingly, dissenting opinions also correlate to interest groups' participation. Amicus briefs allow interest groups to interject themselves into a case. They sometimes influence new judges, but have little effect on veteran judges. After making a decision, the justices can either write an opinion to explain their reasoning or not. Justices often disagree on ideological or legal matters. In one recent case, the Texas Supreme Court limited the public's right to know about private groups that the government funds. 3 justices dissented. Figure 10.3. If the appeals court affirms the lower court's judgment, the case ends unless an appeal can be made to an even higher court. If the lower court judgment is reversed, the higher court can send the case back to the lower court for further action, such as a new trial. In 2019, the Texas Supreme Court reversed a lower court decision, ruling unanimously that while the U.S. Supreme Court had declared same-sex marriage legal, there is still room for states courts to explore the reach and ramifications of the court's ruling regarding whether municipalities must extend city-paid spousal benefits to same-sex couples. The High Court sent the case back to a Houston trial court for further consideration. These redos also allow organizations or individuals to have a second strike at the case. In this case, organizations argued for an expansion of same-sex domestic benefits, and those opposed. Most cases never make it to the appellate level. Less than 10% reach the highest appellate courts. Often, only the wealthiest and most well-connected individuals and groups can use the appellate system to their advantage. Given the time and expertise needed to successfully win cases here, a Texans for Public Justice report found that contributors to judges and justices were between 7 and 10 times more likely to have their case taken than non-contributors. The appellate courts in Texas are divided into 2 types: intermediate appellate courts and the appellate courts of last resort. The creation of this tiered system reflects the suspension of central authority stemming all the way back to the pre-Republic days. But the system is designed to promote the legal access and options available to Texans. Intermediate appellate courts. The first lowest level of appeals courts are the courts of appeals organized into 14 districts. See figure 10.4. These courts agreed to review less than 10% of the appeal cases in 2018. However, many of the courts of appeals cases involve mandatory review, primarily felony convictions in cases without the death penalty. Each court of the appeals has a chief justice and at least 2 other justices. When cases are heard, 3 justices hear the case unless an en banc hearing is ordered where all of the justices of the court hear and consider the case. In each case, a determination is made by a majority of the justices. Appellate courts of last resort. Sitting atop the appellate court structure are 2 Supreme Courts. Why 2 Supreme Courts? Appellants have 1 court for criminal matters and 1 court for civil matters. This creates a dual structure in which cases are sorted by the type of issue. The dual structure was designed for efficiency, but also based on mistrust. The framers of the Texas Constitution were suspicious of the centralizing power of the legal decision-making in any court. Texas Court of Criminal Appeals. The Texas Court of Criminal Appeals makes final determination in all criminal matters, including applying or not applying the death penalty. This court is composed of 9 justices, 8 justices, and a presiding judge. If 4 or more justices favor hearing a particular case, that case is scheduled for argument. However, most of the caseload of the Texas Court of Criminal Appeals, about 80% of its cases, consists of mandatory review of sentencing and direct death penalty appeals. The Texas Legislator determines which sentences must be reviewed, giving the legislative branch a significant degree of control over the judicial branch. Most death penalty judgments are upheld by the court. Texas Supreme Court. The Texas Supreme Court deals primarily with civil matters and juvenile justice and can order either monetary or equitable relief, directing the losing party to do something or not to do something. In 2018, the court reversed about half, 58%, of the lower court's decisions. The Texas Supreme Court is composed of 9 justices, 8 justices, and a chief justice. Like the Texas Court of Criminal Appeals, if 4 or more justices favor hearing a particular case, that case is scheduled for argument. The likelihood of this court hearing a case is low. However, like the Texas Court of Criminal Appeals, if 4 or more justices favor hearing a particular case, that case is scheduled for argument. The likelihood of this court hearing a case is low. However, in most years, the Texas Supreme Court is selective about the cases it takes, as most appellate courts are. In 2018, the court only granted review in 12% of most cases filed, down from 15% in 2007. The system is designed to let lower courts handle much of the work. The cases that float up to the Texas Supreme Court are statewide importance. This is the end of Part 1, Chapter 10.